I'm Drew Stevenson. This is for my professional responsibility class. Here I'm going to be talking about an implied exception to the duty of confidentiality under Model Rule 1.6 that the ABA announced in a formal ethics opinion on March 5th, 2025. And this is for a very specific scenario where the lawyer is actually a victim of the client's crime or someone associated with the lawyer, like the lawyer's employees or family members or things like that. And so, having said that, let's dive in, and I'll give you just the very basics about what this ethics opinion says. So sometimes lawyers, or maybe the law firm staff or their family members or relatives, are victims of various types of crimes. It could be financial crimes or a violent crime or other crimes committed by the lawyer's clients or prospective clients, or maybe somebody pretending to be a client. So this could be a scammer who poses as a client so that the lawyer will transfer some funds to the person. Sometimes the ABA ethics opinion gives a couple hypotheticals about someone who pretends to be a creditor, and the lawyer then agrees to represent them and obtains a check from the other party, but and disperses the funds, and then the other party turns out to be part of the scam, and the check isn't good. And so the lawyer ends up getting charged for the fees or for the disbursement and so forth. Sometimes there are crimes of violence committed against lawyers or their staff or family members and so forth. So what do we do? Well, the lawyer in these situations may need to disclose some information about what occurred. And that's going to probably include something about the representation or the consultation that was underway to the police if they want to find out who this is or have an investigation done or have the person brought to justice, or if the lawyer has suffered a physical injury or property damage or theft. They may need to report it to an insurance company. And then they would need to be sharing some confidential information, probably. So if the perpetrator is really a client, someone the lawyer knows, has agreed to represent, then normally Rule 1.6, which is the duty of confidentiality, would apply to at least some of the information that might be necessary to share. And if it's a prospective client who came in for a consultation or arranged an online consultation, then that person would also be protected, have some confidentiality protections under Model Rule 1.18. Now, there are exceptions to 1.6, and those are in Section B of the rule. They are, I would say, codified or express exceptions. And some of these scenarios, like to prevent other crimes by this person, that might apply here and give the lawyer some leeway to disclose, so let's say, to law enforcement what has happened. But this opinion basically announces that there's now also an implied exception to the rules for these situations where a client or someone pretending to be a client has committed a crime, has victimized the lawyer or the lawyer's staff or family. And now it also talks about the problem of scammers, right? So, and this has been happening in some ways more and more to lawyers and law firms where the perpetrator is a scammer, basically pretends to be a client, or maybe digitally or online impersonates a client, sets up something that looks like the client's bank account or and email address and so forth. And in these situations, the ABA is taking the position that they're not making a bona fide attempt to obtain legal advice or other legal services. So if they're a fake client, a phony client, then there is no real legal representation underway, and therefore no duty of confidentiality under Rule 1.6. Now, I also want to tell my students that this ethics opinion presents 4 hypothetical scenarios. And first, I think one or more of these is likely to show up on the MPRE sometime in 2026 or 2027, if that's when you're taking it. And they're also likely to show up on my exam. It's a sort of irresistible to turn those into multiple choice questions. And so the first two are about scammers, basically, who contact the lawyer posing, let's say, as debtor creditors, and they want the lawyer to help them get some funds, and it all turns out to be a ruse so that they empty out the lawyer's trust account or get the lawyer to disperse some funds to them wrongfully, and the lawyer doesn't find out about it until it's too late. The third hypothetical is about a situation where a client or is in the lawyer's office for a consultation or for a meeting. It's bad news. The client gets very upset and pulls out a firearm and shoots the lawyer or some of the law firm, one of the staff at the law firm, in a rage. And so there are cases where there are crimes of violence perpetrated by or even brandishing a weapon in a lawyer's face. And then the fourth hypothetical that they give is a scenario where maybe the lawyer leaves a client in their office just for a minute while they step out of the room to ask the secretary something or hand them pass off a document or ask for copies to be made. And in that brief moment of time while the lawyer is out of their office and the client is in there alone, the client steals something from the lawyer's desk, maybe the lawyer's wallet from a drawer or the lawyer's phone or something like that. And the lawyer doesn't realize it until the client is long gone. And so these are the type of cases where you may need to explain to law enforcement or to an insurer why this individual was in your office or why they were corresponding with you and induced you to make a fund transfer or something like that. The other thing I want to say about this is that's an interesting part of the opinion is that even though it's saying there's an implied exception here, it also notes that historically, some of the times in ethics opinions where the ABA has announced an implied exception to the rules, especially the confidentiality rule, within a few years after that, the implied exception actually gets codified in an amendment to 1.6. And so some of our amendments, some of our exceptions in 1.6b were prior to being added were implied exceptions, at least according to the ABA and their ethics opinions. So that's it. Just keep in mind, if the lawyer is the victim of a crime, there may be some leeway. Oh, one other caveat. It's not an excuse for the lawyer to share lots of gossip about the client or divulge information that's not really relevant to the incident that occurred. So the lawyer should share no more than necessary in terms of the confidential information in order to enable law enforcement to undertake an investigation and find the person, or for an insurer to verify the claim. And that's it for ABA Ethics Opinion 515.